Well, there can be all kinds of situations. Homeowners can sue based on breaches of fiduciary duties. In other words, the association collects assessments. They're required to use those assessments to maintain common elements. Sometimes there are supposed to be separately funded accounts for limited common elements, and there are suits that are brought by owners. In those scenarios, there are times when the members will try and recall a director, and there's counsel needed or required by the board to have counsel representing them on those types of issues. Sometimes there'll be a suit filed by a member asking for declaratory relief, which is basically saying our position is that we are allowed to do X. And it may be like something as simple as modifying a portion of their unit. And the association has told them, no, you've been rejected by the Architectural Review Board or the Board of Directors, or sent them a letter saying, no, we don't agree that this modification is allowable. And so you may have to go through the alternative dispute resolutions that are in the statute, which would be arbitration for condos, mediation for HOAs. But sometimes if you get past that area, or if it doesn't apply, because there are only certain quote unquote disputes that apply where you have to go through that alternative dispute resolution. But if you get past that area, then a member will ask for declaratory relief, which is basically saying, we want you, judge, to tell us what you would do if this did go to trial. So it basically asks a request of the judge to make a kind of preliminary decision before anything's happened and tell the owner, yes, you would be able to make that modification and the association's position is wrong, or the association's position is right, and if you build this, then they're probably going to have a cause of action against you. So those are just some of the issues that members bring up. I mean, there's parking issues, there's animal-related issues, anything where there's either a statute involved or a declaration term, any of the governing documents, rules and regulations, and a member says that they're in compliance and the association says you're not, and then they go ahead and file suit. Or if the member thinks that the association has not been acting rightfully, which was the instance I brought up about the fiduciary duty about spending money the right way, then those actions need to be defended. And one thing that I think a lot of people are not aware of, even board members are not aware of it. They should be, but a lot of them aren't. And that is in the state of Florida, the corporation cannot represent itself because it's not a natural person. So there's a requirement that corporations have counsel represent them in court. So if you have, even though the associations are filed as nonprofits, anytime an action is brought against them, unless they want to be defaulted, then the association needs to bring counsel in to defend that action.